Alright, my name is Mr. Henry Appiah. I'm the Director of Risk Management here at the Radiant Rock Hospital. And today I am going to be discussing an issue that happened here, and I also bring on board some of the technicalities involved in medical records and all that, and giving you some details on this event here. So, came up, with the problem, the root cause of the problem, which is lack of better communication between Mr. Jones's family and the clinic, and the data collection. I don't know what happened to the data, since there are some discrepancies and insufficient validation, and as well as documenting the necessary information that we needed to document and keep in our records, and also and the naivety on behalf of the staff, and as far as the legalities involved in this issue. So when it comes to patient coming to the hospital, the first thing you do is to think about consent to treat. Okay, you give the patient necessary information about their treatment and their situation and what is going to be done, and you let them make the decision as to if they want to still go ahead with the treatment or not. But you provide them with the information, and this procedures has to be validated. The validation is based on what the patient voluntarily decide to do, given all the information surrounding the treatment procedures and protocols here. So patient will decide whether to go ahead with the treatment or decide not to go ahead with the treatment, but that should not be influenced by anybody. Those decisions taken by the patient should not be influenced by anybody, be it the physician, the staff here, family member, and all that. But information has to be given to the patient for the patient to make the decision regarding the protocols here, as far as the risk and benefits of the treatment given to him here. And if he or she chooses not to, they can find alternatives, give alternative information to the patient as to what else can be done for him elsewhere, and the patient make that decision. But the patient should be in the right frame of mind to make those decisions. And also we have to document this. We get the patient working, we talk the patient agree verbally. During our intake, we document it in the patient records. Then the patient is given consent forms to fill out and sign. If the patient is incapable of signing or anything like that, they can have a surrogate, a family member who came here with them and all that, to sign for them. But both documents, both the oral and the practically signing of the document, has to be recorded in the patient's records. Okay. So type of consent, we have the express consent, where patient is informed and patient agree that orally agrees that they've heard, and also sign those papers. They've heard, they understand the risk and benefit involved with the care. Then there's also the implied consent, where patients are incapacitated in certain circumstances. Something happened, they cannot talk, they cannot walk, they cannot sign, and they are dying. Then physician will take upon themselves to go ahead without informing patients, family, because the situation demands that physician go ahead and save life of the patient. So they go on and do their treatment for the patient. Then when it comes to the implementation, there are so many models that have been used in the medical field. There's the event model. We treat informed consent as a procedure that happens just once. Today, when the patient's working, we did everything and that is it. Then there's the process model, where there's rather a relationship that is built up between the patient and the physician. The patient is so much involved, has an upper hand and some kind of powers in the interaction to make some of these decisions, and it's so much beneficial to both parties, the patient and the doctor. Okay. Then when you go to certain states, there are legal bases where this consent to treat is established. So for a place like Georgia, it's a standard protocol given to physicians to follow, okay? Because we just don't want physicians to do anything at all and putting patients' life at risk and all that, and putting their own liabilities on their own licenses online, okay, and liabilities. So they've chosen a standard protocol in Georgia backed by law that physicians have to follow when they are treating their patients. And it's also same fundamental legalities that have been established for do not resuscitate. When somebody is dying and cannot breathe, they make their own rules, with the physician or backed by a legal document and say, hey, when I'm in this stage, please do not try to get me alive. Just let me go. I don't want my family to go through all the emotions and financial strains. So it's just about time for me to go. Do not try to give me oxygen or whatsoever and let me go. And some of these informations are documented by physician in patient records. Okay, and sometimes patients will elect somebody to stand or we backed by a legal document, okay, a power of an attorney, and say, yes, I stand on behalf of the patient, and say, patient did this, patient actually asserted and said, patient really said they shouldn't be resuscitated when they die. They are in this vegetative state or incapacitated state. So I sign and append my signature. We should let the patient just go smoothly and nicely. Okay, so as you can see, the law is listed there, and it's backed by power of an attorney, where it becomes backed by a legal document. Then when it comes to electronic health system, it's very important system that gives hospitals advantage, keeping patient record, recording everything patient said and all that, because sometimes it become a legal document in times of suits, because anybody can walk into your hospital and say whatever. I say, when I came here, doctor did this, did that, and that caused my problems. But if you have the records and documents, you can, defend yourself. So you have to, the system is very important, and it has to be used properly. And this is what has caused some of the problems here at Radiant Rock that we are dealing with right now. There cannot be naivety involved with recording patient information, okay? People don't know what they are doing, or somebody don't supervise somebody to make sure the proper information are recorded, devoid of any discrepancies or whatsoever. Okay. So in summary, we will be connecting the consent to treat, which involve informed consent. Information is given to patient. Patient get this information, make sense of it, and agree that yes, I want to be treated. In the absence of any capacitation, and patient is sick and weak and cannot talk and cannot do anything, then doctors, physicians have the upper hand in saving these patients by the code of ethics of their practice, or being a doctor, the oath you sign. Anybody who walks in, dying or whatsoever, you still have to treat the person. Then all this information have to be validated and documented, and also implemented actively and recorded. Okay, when it comes to the do not resuscitate document, it must be also recorded. What patient said and what doctor recorded must be the same. Okay, there cannot be patient said this and doctor put something different, or physician put something different. Then patient can also give the legal rights to a family member, a friend, or somebody they know to be able to say that this is what patient did, patient said this, and I sign off that, and let whatever patient did, patient said should be applied. Okay, so it's backed by power of attorney. Then these are the recommendations for this hospital. There are a lot of things that we have to change here in order to avoid such mistakes. So we want to create standards, and we have to identify those standards and make sure we put in place things that become effective for us to be recording, and making sure we're getting the right information from the patient, and those information being recorded the way they are to be done. And the tools have to be in place for those to be done. We have to have a robust system here to be able to record, keep the information secured, and not something that can be found anywhere, hacked into, and all that. And this information have to be reviewed constantly so that we know we are doing the right things here. Okay, it's not a play matter, because it's a thing that can cost the hospital so much, millions and all that. And staff will be taken to courses, to refresh themselves on what to do and what not to do as far as patient records are concerned. And we have we update our systems here, and also have a collaborative model of healthcare where we involve families in some of these recordings or records, and you have families involved. So in the cases of those who are patients who are incapacitated, we will need their families involved, and to make it effective. And following federal laws, state laws must be our guiding star, okay, as far as guardianship rights, patients, family members are concerned. And we must also be aware of the legal consequences when we don't do these things right, because a lot of us don't know and we just do anything we want, right? And these are the references. Thank you. And I'm sure I will come back here again and keep us refreshed on some of these things.